folks, thanks for bearing with us. For those of you who don't know me, my name is Charlie Bogren. I'm the president of the KU Federalist Society. Thank you all so much for coming out. This is a fantastic crowd. Hopefully you guys enjoyed the barbecue and you're going to enjoy a fantastic debate. I'm going to hand this over to Professor O'Shea here really quickly, but I just want to give you a brief introduction. Professor O'Shea is actually a native of Kansas City, Harvard Law graduate, clerked for the 6th Circuit Court of Appeals, then was in private practice in Kansas City for several years, in Chicago as well. And now he's a professor of law at Oklahoma City University School of Law. And then, of course, Thomas Stacy, Professor Stacy is a double Michigan graduate. Go Blue, got to put that in there. He's, since 1986, been here on staff, and he also clerked for the DC Circuit and the Court of Appeals as well. So hopefully you guys will enjoy. We're going to have a little back and forth, and then we'll have Q&A at the end. So thank you, and please join me in welcoming Professor Stacy, or Professor O'Shea.
Thanks very much. It's an honor to be here, and it's a pleasure to be here. I still think of this as native stomping grounds. I'm here to talk today about what constitutional law has to say about the law governing the carrying of handguns for self-defense. And then I'm also going to talk some about some of the recent changes in Kansas law. And the basic point I'm going to argue for is ordinary procedures of constitutional reasoning, the kinds of stuff that if you go see a standard text like Philip Bobbitt on constitutional interpretation, it'll give you a list of the kinds of arguments, the kinds of considerations that courts regularly rely on when they recognize constitutional rights. And my argument is that if you apply those to the carrying of a handgun concealed, it yields the conclusion that that's protected conduct under the Second Amendment to the federal Constitution and also under many state constitutional right to arms provisions. And I'll argue that the right can be regulated in certain ways, but not in ways that prohibit its exercise or frustrate it from being exercised as a matter of practice. And then I'll finally argue that in some ways the state of Kansas has chosen to regulate less than it would be constitutionally allowable to do, and I'll talk about some of the choices that it has made. So, the first thing that, the first line of argument that I'm going to start with, the first set of considerations, is a familiar one. It's history. And if you've read the two landmark U.S. Supreme Court cases, Heller and McDonald, you know that they are saturated in history and in U.S. tradition. They're sometimes called originalist opinions, and they are that, but they're more than that. And even if you're not a strict originalist, if you still believe history has something to say about how we should understand constitutional provisions, Heller and McDonald have a lot to say to you on that score as well. I do want to mention throughout this discussion, Kansas quite recently amended its state constitutional Bill of Rights, and it's a pretty strong and clear provision. One of the more strongly worded state constitutional provisions makes clear that self-defense is the very first purpose for which persons have the right to keep and bear arms. Shortly after the Second Amendment was ratified, commentators and then courts, state courts primarily because there were no federal gun laws, state courts began to weigh in on the meaning of the Second Amendment and the meaning of the right to bear arms more generally, and they regularly held that it included carrying handguns and other common weapons for self-defense. So in the interest of time, I'll just give a taste. 1846, state court case, a unanimous state Supreme Court held that the Second Amendment was violated by a ban on handguns, and that banning the carrying of handguns also violated the Second Amendment, and treated that as a basic component of the right to self-defense. The government could regulate the method of carry, and that's important. That's a constant thread throughout American history, by banning concealed carry where open carry was allowed. So carrying in a visible holster on the belt is open carry. But it couldn't destroy the right by prohibiting both methods of carry. The first major commentator on the Constitution, federal judge, U.S. attorney, and law professor St. George Tucker treated it as straightforward that the right to bear arms under the Second Amendment included carrying for personal purposes like self-defense and hunting. Tucker took the view that it made no sense for the law to presume, and American law would not presume, that people were up to no good if they were seen in public with weapons, because, as Tucker said, there's a constitutional right to bear arms in America, and in many parts of the U.S., a person would routinely go out of their house with a rifle or musket in their hand, just like a European gentleman would carry his sword. So this is the exact paradigm of right to carry today, personal right to carry common weapons for self-defense and other purposes outside the home. Throughout the years, state courts and federal courts have on numerous occasions struck down laws prohibiting the carrying of weapons outside the home as either violations of the Second Amendment or as violations of the right to keep and bear arms under state constitutions. If you look historically, the most commonly struck down type of law under the American right to bear arms is prohibitions on carrying outside the home. So now I want to continue the historical account, but I want to talk about more recent history, and I want to talk about prudential argument. Scholars will commonly tell you the courts care about what works, too, when they look at defining constitutional rights. They like to rely on the experience of the states, and the famous idea of Justice Brandeis, that the states are a laboratory of federalism, and we can try out new ideas or new regulations in the states, see how they work, and then the federal courts will decide constitutional claims based on that experience. They look at state constitutions. The switch that we've seen in the last two generations is that traditionally open carry was the socially preferred mode of carrying handguns in America. The idea was forthright, upright citizens with nothing to hide would show you that they were armed, and everybody would be on an equality, and only suspicious people who had something to hide would conceal a gun. In the 1980s, the more urbanized United States, that set of social norms had passed away in a lot of parts of the country, and if anything, concealed carry had come to be viewed as more socially acceptable. And the key innovation that really started taking hold in the mid-80s when Florida went over is the shall issue concealed carry permit. This is one of the most successful state-level regulatory ideas in generations. And the idea was there's an enumerated set of criteria. You can't be crazy, you can't be addicted to drugs, you can't have a criminal record, and if an applicant meets those criteria and typically takes a short training class, gets some instruction on the law of self-defense, and some live fire training in most states, they are entitled to get a concealed carry permit, and they can lawfully carry concealed. More than 40 states today make available shall issue concealed carry permits. Only a handful still have may issue concealed carry laws where the authorities, the local sheriff, whatever, have discretion to deny a permit, and often will deny permits in most or even all cases. There are currently no jurisdictions in the United States where there are no permits made available for concealed carry. DC and Illinois were the last ones, and their laws were both set aside by courts. There are somewhere between 12 and 14 million concealed carry permits active today. Nothing has regularized and made feasible and socially acceptable the actual exercise of the right to carry arms for self-defense more than the innovation of the shall issue concealed carry permit. It was the sort of breakthrough innovation. It is becoming something that people from different demographic groups are also participating in. These are the trends from the state I know best, Oklahoma, where I live. And you can see the rate of both the rate of increase and the raw numbers in just a decade for women, African Americans, American Indians, are exponential increase. About a third of the active permits in Oklahoma today are held by women, and there are about 200,000 active permits. So this is a method of regulation that makes it possible for people to exercise the right as a practical matter. The other striking detail is this is the laboratory of federalism working. Well, the results are in. Shall issue concealed carry permit holders are overwhelmingly law-abiding. There are a lot of empirical measures that suggest they are actually less likely to be convicted of crimes than off-duty police officers. In Oklahoma, we have about a 0.06% revocation rate for misconduct. There are about 200,000 active permits, and you'll have somewhere between 30 and 40 a year revoked for misconduct, and that includes things that don't have anything to do with firearms. Several hundred thousand defensive gun uses a year, and that's the low end of the peer-reviewed literature. There are solid studies that have held up to methodological criticism that say it's more like 1 or 2 million defensive gun uses a year. Potential mass shootings have been averted by concealed carry holders. There was a few months after Illinois went shall issue, there was a crazy person who opened fire on a crowd in Logan Square in Chicago, and an Uber driver with his concealed carry permit got out and returned fire, went 4 for 6, hit no innocent bystanders. The New York Police Department could probably use some marksmanship instruction from this guy, and stopped the threat, and stopped a potential mass shooting in its tracks. Brings me to Kansas. Recently, there has been a trend of states deciding to omit the shall issue permit requirement and adopt permitless concealed carry. Some proponents of this call it constitutional carry. I respect the position. I think shall issue permitting statutes satisfy strict scrutiny. They're narrowly tailored to protect public safety and without unduly burdening the right. And so I don't think the Constitution requires permitless carry, but Kansas is a permitless carry state, and in fact, your neighbor in Missouri, my native state, just adopted permitless carry last night, actually, in the legislative session of the Missouri legislature, so that'll be going into effect soon. For decades, the only permitless carry state was lonely little Vermont, up in the upper right corner. But in the past 15 years, it's now not an exotic position. There are 10 states now, and the number of different regions of the country, and it's growing fast. If you put the shall issue states plus the you don't need a permit states together, this is what a supermajority of constitutional magnitude forged over 30 years looks like. The only holdouts that are left are California, Hawaii, and the Acela corridor, for those of you who have worked on the East Coast. So where that leaves us is, I do think that there is such a long tradition, and history should matter to us too, of saying that legislatures can regulate